So the Ninth Circuit Court of Appeals just decided in Young v. Hawaii that you do not have a Second Amendment right to open carry a firearm in public for your self-defense. Let's talk about this. But real quick before we jump into this video, if you think that you have a Second Amendment right to carry a firearm in public for your self-defense, go ahead and hit that like button and subscribe. I also want to give a shout out to two of the main sponsors of the channel. The first being Acelink Armor. Acelink Armor is a plate carrier company. They have plates and they're here out of the state of California. You can get bundles like this that are great quality, great value. They don't break the bank. And if you use the code ARMSCHOLAR, you will get 10% off of your order. I also want to thank USCCA for supporting the channel. Through your membership, you get self-defense liability protection as well as education and training. And if you carry a firearm, I highly recommend you look into some sort of legal protection like through USCCA. And I'll put a link to them down in the details section. So like I said in the intro, we got an absolutely baffling decision out of the Ninth Circuit in the Young v. Hawaii case. If you're not familiar with what this case all entails, I have multiple videos on my channel that walk through Young v. Hawaii and what it deals with, but just understand that Young v. Hawaii was generally a challenge to Hawaii's statutory language, which required people to show that they had an urgent need for an open carry permit. Although Hawaii's statute said that people could generally obtain an open carry permit in the state, the practical application of this is that very few people ever even obtained a carry permit, an open carry permit, because they just were simply not issued. Mr. Young was one of those individuals. Twice he applied for an open carry permit, but was denied. He then sought recourse by the district court, which denied his challenge. Mr. Young then appealed that decision up to the Ninth Circuit, and a 3-judge panel found that individuals do have a right to open carry, specifically also bouncing off the fact that the Ninth Circuit has already closed the door on the issue of concealed carry. In the case Peruta, the Ninth Circuit said that you do not have a right to concealed carry. Therefore, the 3-judge panel in the Ninth Circuit, when dealing with this issue, said, well, if you don't have a right to concealed carry, then you must have some sort of right to carry in public. That must mean that you have a right to open carry because the Second Amendment says you have a right to keep and bear arms. Therefore, if you have a right to bear arms, you must be able to at least carry a firearm open in public. The 3-judge panel leaned heavily on history that was presented to them in a very historical determination. The 3-judge panel found that you indeed have a right to open carry in public. That determination by the 3-judge panel in the Ninth Circuit was then sought for review by the 11-judge panel in an en banc review. That is what that means. It was an en banc review, 10 randomly selected judges, and then the chief judge. So 11 judges reviewed that 3-judge panel's determination that you do have a right to open carry under the Second Amendment. Well, after review, the en banc panel in the Ninth Circuit disagreed with the 3-judge panel and agreed with the district court, indicating that you do not have a right to carry a firearm openly in public for your self-defense. Now, after going through the opinion of the majority, which took quite a while, it's a very long opinion, and it took me a while also because it was extremely frustrating reading some of the opinions they have. But I will read some things to you that stuck out to me and really just show really how baffling their decision really was. So what the majority declared, and this is also quoting the dissent in their opinion, they said that the majority has essentially declared in their opinion that a state may constitutionally forbid all public carry of firearms based on the utterly inconsequential fact that the lawful manner of open public carry has historically been subject to modest regulation, but has never been outright prohibited. So here, the dissent is talking about the majority's decision. The majority primarily based their decision and their determination on the fact of that they pointed to some historical context in early American law and in English law, saying that there were some restrictions on the manner in which people can carry firearms openly in public. That is a historical fact. They used those modest and rare regulations as a basis to say, well, if there are manner restrictions in early American history, that means that you do not have a right to carry a firearm openly in public. To quote the dissent further, they stated that today, a majority of our court has decided that the Second Amendment does not mean what it says. Instead, the majority holds that while the Second Amendment may regulate the right to keep a firearm for self-defense within one's home, it provides no right whatsoever to bear, i.e. to carry that same firearm for self-defense in any other place. And this sentiment is seen throughout the dissenting opinion, saying pretty much that the majority outright crossed out your right to bear arms under the Second Amendment. Our Second Amendment right is the right to keep and bear arms. In Heller and as well as McDonald, they address that right to keep. You have a right to possess a firearm in your home for self-defense. But that didn't address the aspect of to bear. To bear, and commonly and historically, was seen as your right to have a firearm on you out in public for self-defense. That is your right to bear arms. However, here, the Ninth Circuit pretty much said, we don't agree with the Constitution. We don't agree with the Second Amendment. We don't even agree with the Supreme Court and Justice Scalia's opinion in Heller that you have a right to carry a firearm potentially out in public for self-defense. They are saying we're going to completely just cross that out and limit your Second Amendment right purely to your right to keep a firearm, and only that right to keep a firearm in your home for self-defense. Now, since this opinion came out, a lot of people have been asking me questions about what are the broader implications of this majority's opinion. So first and foremost, this affects all those individuals within the states that fall under the jurisdiction of the Ninth Circuit. These states include California, of course, Oregon, Nevada, Arizona, Idaho, Montana, Washington, and Alaska now have this binding precedent from the Ninth Circuit en banc that other courts can lean on and point to as a basis for restricting individuals' rights to carry firearms openly in public. Now, does this mean that in your state you are banned from carrying firearms openly in public? No, it doesn't mean that. But what it does potentially mean is that if your state decides that they want to ban or restrict your ability to openly carry a firearm in public, they now have this precedent to point to that says they can do that. This also goes to another question I've been getting quite a bit about how expansive is this decision on other circuits. Again, this is a Ninth Circuit en banc Court of Appeals decision, so it is binding on all those courts within its jurisdiction. It is not binding on other circuits. However, other circuits could potentially cite to this decision as a basis in cases that they might handle dealing with open carry. Even more so, what this means for us under the jurisdiction of the Ninth Circuit, this means now that we not only have the Young decision, but we also have the Peruta decision, which jointly then say you do not have a Second Amendment right to either carry a firearm openly in public for your self-defense and or a right to concealed carry a firearm in public for your self-defense. You do not have either right. You don't have a right to concealed carry and you don't have a right to open carry. Now, in my opinion, I think this decision by the majority directly goes against the history that we have in the US, as well as the text of the Second Amendment, being that they completely write off your right to bear arms. Even more so, they outright ignore the Supreme Court's decisions in Heller and McDonald as well, alluding to your right to openly carry firearms in public. So I think at all levels, the Ninth Circuit en banc panel got this just absolutely wrong. So thank you guys again for being patient with me and getting this video out. Like I said, I wanted to read the opinion for myself, draw my own conclusions, grapple with the rationale that they put behind why they made their determination. It was like 120 pages. It took a while to go through it, but I appreciate you guys being patient with me, and everybody who said, hey, are you gonna do a video on this, having questions, I greatly appreciate that. I also want to mention that we are rapidly approaching 100,000 subscribers, so if you're not subscribed, I highly recommend and would greatly appreciate if you guys subscribe to this channel. So if you like this video and like to support the channel, one of the best ways to do that is to like, comment, subscribe, and make sure to hit that notification bell because that helps the channel analytics, helps us spread the word about the Second Amendment, and also spread the word about Second Amendment infringements like this that are going on in the US. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.